Good evening, everyone. My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing coercive control, and we are incredibly grateful that you are all able to attend tonight. As a member of the Colorado community for over 30 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service that we provide to our community. Now, I would like to introduce our presenters today, Jenny Ray and Dan Droege. Jenny Ray is one of the Harris Law Firm's most accomplished attorneys and a partner at the firm. She's a passionate advocate who has dedicated her professional career to making the law clear and accessible to those who need it most. She's helped numerous individuals and families protect their rights in high-stakes family law cases. Dan is an experienced family law attorney and certified mediator at the Harris Law Firm. In practice since 1987, he has extensive experience in divorce and family law matters, including complex and contested cases involving custody and placement of children, child support, alimony, grandparent and third part and oh my goodness, excuse me, grandparent and third person rights, non-traditional family cases, and alternative dispute resolution, including mediation. All right, without further ado, Jenny and Dan, I will turn it over to you.
Very good, Izzy. Thank you so much, and welcome everybody on this beautiful Wednesday afternoon here. Just a few additional kind of housekeeping items before we get started. I will tell you that yes, just we like to present these webinars as a way to provide general information to the public. We want to provide this information as a resource for folks that they can come back to later in, down the line and continue to repeat to come back and see us. However, I will tell you that this does not create an attorney-client relationship, just so you know. This is just general information that Dana and I like to share with folks, so we're just helping folks out in the future. I will also tell you that, you can also see that Dana and I are clearly in different spaces. I think I like Dan's space better, though. I will tell you, Dan. And so I will tell you that, because of that, we're all working on the internet here for this webinar. And so just please bear with us if our internet happens to go out. I'm in the mountains. My internet is choppy at best at sometimes. So please bear with us, but so I promise we'll be able to sign back in. As Izzy also mentioned that the materials, you'll be able to retrieve the materials for this evening's webinar online as well. And lastly, I will tell you that we're also human. So if you happen to hear a dog barking in the background, I'll have to tell you, I just heard my husband start a chainsaw outside. I have no idea what's going on. So my apologies. So please bear with us on any kind of snafu, if you will, moving forward here. All right. Well, so we wanted to just kind of take a step here and just explain, kind of an overview of tonight's webinar. We want to discuss, why does this new law matter? What are the definitions of coercive control? What are some examples that we might be seeing? And we'll then at the end of the webinar have a question and answer period for us to address. And Izzy, feel free to advance forward if you don't mind.
Did it move forward for you?
Yes, it did. Dan, you want to go ahead?
This is just a general statement of what it, I just don't want to read it to you, but what they're trying to do is bring together in one spot what we've historically looked at from different areas and trying to fit it in under certain things the court has to consider. And so generally, as you can see on this screen, we're looking at coercively controlling somebody by a pattern of acts or threats, humiliation, bullying, that tends to influence or coerce, frighten another person to get them to do what they want, especially in our field in some sort of litigation regarding children or property division. You can move ahead.
So sure. So a little bit of the origin of the term coercive control. I believe that this had come from a gentleman named Evan Stark, an American sociologist and social worker. And Izzy, if you'll just advance one more time, I believe there's an additional quote. So, the thought being is that, we've all heard of domestic violence. We've all heard that, certainly emotional abuse and verbal abuse and manipulation, but the thought is that, you know, coercive control, really kind of the meaning behind it is, you know, it's where the victim becomes captive in an unreal world created by the abuser and trapped in a world of confusion, contradiction, and fear. Simply meaning, you know, oftentimes folks think of, you know, domestic violence as just being, you know, the actual physical abuse, but it's much more than that. And I believe, just as Dan said, that Colorado wanted to kind of encompass kind of these other forms of domestic violence as part of this coercive control as that. And so this is where this kind of term was kind of coined, if you will. And there's his book that if you're interested in reading further, feel free to advance. Thank you.
Just so you know, this is relatively new for Colorado. Just last August, they put this into law and defined it as we've already been discussing the coercive control.
And similarly, oh,
Go
go
ahead.
ahead. Sorry, Dan. My apologies. And similar to like what I mentioned a moment ago, what does it mean? You know, certainly this we're trying to get it kind of I believe that the legislature was trying to kind of encompass that this is a real a phenomenon that happens in relationships, and wanting to make sure that, you know, that the domestic violence definition was not just so narrowly kind of viewed, and that these other pieces are also kind of being incorporated into this consideration of domestic violence. And here, as this, you know, as this discusses, that this is absolutely a type of domestic violence in domestic relations cases. Thank you.
And so why it matters is the court's now required, like I mentioned before, you take pieces from everywhere else and try to fit it into a definition of why it's important for the court to consider something or some behavior of one of the parties. Now with this new law, it says, hey, you have to consider this, right? You have to look at this and how it impacts, for instance, in this slide, the best interest of the child, rather than trying to say, well, this is happening and this fits under this consideration, and this is why you should look at this, Your Honor. Now it's actually there and the court's obligated to consider it.
So what is coercive control, and how does Colorado law define it, right? We have this kind of, you know, philosophical definition of what it is. How does the state, and how does it impact your legal matter if you have a child custody case? And so, Dan, I can take with this one if you want.
Sure.
And so coercive control is basically defined in our best interest of the child statute, 1410-124. And frankly, if you wish, you're more than welcome to go to, say, Google and just type in that CRS 1410-124, and it's under 1.3 is the definition. And so here you can read this. But it's a pattern of threatening, humiliating, or intimidating actions, including assaults or other abuse, that is used to harm, punish, or frighten an individual. And that includes a pattern of behavior that takes away the individual's liberty or freedom and strips away the individual's sense of self, including the individual's bodily integrity and human rights. And thank you for copying that, Izzy.
Yeah, that's great. And so this just breaks it down even a little bit further. As you can see, these are almost examples also: isolating the individual from friends and family, sort of monitoring, surveilling, regulating, or controlling finances of the child or a relative, any economic resources, or maybe access to certain services. Another, monitoring, surveilling activities, trying to figure out, you know, where they're going, who they're seeing. And finally, what I always look at more, real bully, name calling, degrading, demeaning actions against a child relative on a frequent basis. You can clearly see that they're doing this to secure some sort of result.
And these definitions continue, these examples, kind of what the court is looking for underneath this statute. The court also says, whether the court considers behavior such as threatening to harm or kill the individual or the individual's child as coercive control, threatening to commit suicide themselves or otherwise harm one's own person when is also used as a form of coercion and control. And lastly, that if a person is threatening to kill an animal of an individual is also a form of that coercive controlling behavior, which I know is very important to Dan and I as well.
And again, it continues, threatening to publish, personal information, photos that was shared at better times, and trying to, threatening to do that. Damaging property, we kind of looked at that. Threatening with deportation or regarding immigration status, reporting people to the authorities. Or forcing them to take part in criminal activities. Like, you better do this, or, there's going to be a result if you don't help me out with this.
So, thank you, Izzy. So with this, so like we mentioned, this is the best interest of the child statute. So if you've been on any of our former webinars or spoken to any of us, I'm sure you've heard us talk about the best interest of the child standard. So in any custody determination, basically the allocation of parental responsibilities is what we call it here in Colorado, but it's, basically for kind of ease of reference, kind of called a custody matter. This is the statute that the court must consider when assessing parenting time and decision making. And parenting time is actually like the physical time spent with a child, and decision making responsibilities is basically which parent is going to be making those major decisions for the child. And so this statute, this coercive control statute, was incorporated within that best interest of the child statute. And so therefore, the court must consider these factors when considering parenting time and decision making. And what the court has done, as it's mentioned here on this slide, is basically consider that coercive control equals domestic violence.
And how this could impact individual cases going through is referred to as ramifications. You could demonstrate to the court that this is taking place. It could form the basis for protective orders, form the basis for domestic violence and domestic abuse. It could, if it's a financial control, you could see this impact perhaps property division, depending on the severity of what's happening, if there's depletion of the marital estate, some other stuff. And I'm not, it says that it could form a basis for criminal charge. I can't address that as I'm not a criminal attorney, but I anticipate it could. If it's serious enough and it's considered domestic abuse.
So this is kind of the conversation piece of where we're wanting, Dan and I just read off like many of the factors that the court considers, but this is where we, wanted to also discuss various examples here. And so bear with us, we have a handful of slides to discuss these examples as well. But, largely, sometimes folks just kind of might not consider that behavior as coercive control, but you might find that it actually is. And so, those examples, just like Dan had mentioned before, of that isolation, oftentimes, that coercive control, isolating one from friends and family, one's support group, from any kind of even care, isolation from their, medical team and treatment providers. That can be a sense and form of coercive control. Controlling access to money, like Dan mentioned a moment ago, not being able to access bank accounts or taking that behavior, taking that kind of authority away, or even just monitoring, kind of how much is being spent, itemizing those kind of that controlling behavior and access to money on a regular basis by, discussing kind of, well, what was spent here, what was spent there, etc. Stalking behaviors such as, monitoring behavior throughout the day, that can be like literal physical monitoring, like through, Apple tags is a big one. Cameras, ring cameras, those have, certainly been on the rise these days. But also, by things that might not be so prevalent and like noticeable by the individual, like through spyware. There's certain technology that exists that someone can access, that can place on a computer, where you can basically figure out passwords to different emails, accounts, etc. And so installing that spyware can absolutely be a form of domestic violence and this coercive control. Basically, the stalking behaviors being that, thank
Go
you,
ahead.
making themselves being, kind of omnipresent, like, well, where were you today? Why were you at home when you're supposed to be at work? So, that type of behavior, it might not be like the physical following of someone, but actually, just that, well, I saw you hit, register the ring cam. What's going on there? Another example are name calling and insults. That's a big one, because that's the form of that humiliation and intimidation that we mentioned in the definition. And like we mentioned a moment ago, controlling aspects of your health and body, monitoring your food and calorie intake, your time sleeping, your time away in your bedroom, your time away in your restroom, those types of things. That can all be examples of coercive control.
Some of these, we just wanted to go through them. So some people don't think of them. Some might be obvious to everybody. But verbal abuse again, humiliation, excuse me, degradation, threats. I think that just anything that controls or asks very invasive questions on a repeated basis of just trying to something to question as to what's the purpose. And some of this obviously weapons sometimes just sitting out in a manner, they might be unloaded, but just sitting there as a statement. And the others are exact opposites. Well, I'm going to hurt myself, like we've talked about suicidal statements, or I'm going to do this to myself because you don't love me, and but if you come back to me, everything will be better, and I'll be a better person. That certainly is coercive behavior, and it happens. It's an amazing thing that people will do.
So again, here's some additional examples, something to think about, turning the children against you, and that can, certainly be, very blatant, or it can be kind of insinuating behavior, right? Like, well, your mom didn't do this today, or your mom wanted you to do this, but I didn't think so. Those types of statements can be very harmful and damaging to the relationships, not only with your kiddos, but again, that's that type of controlling behavior. Again, that threats to pets. Colorado actually is, in the domestic violence statute, threats to animals is certainly a form of domestic violence. So even those threats can be considered this coercive control. Similarly, the social media shaming, including use of sexually explicit details, content, absolutely. That's a form of this coercive control. Sharing that kind of very intimate information, in social media, the courts must consider that type of behavior, as well as damaging property. Some folks, might say, well, domestic violence doesn't, I just knocked a table over, or I just punched this hole in this wall. And the courts say, no, 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 that is absolutely a form of domestic violence, because that is, although there's no actual physical harm to that person's being, the intimidation factor is something to be considered.
Yeah, I think you can look at a lot of it, like Jenny just said, it's the impact on the person. It doesn't have to be physical. And again, like threats, I'm going to report you to, which is big these days, to immigration. I'm going to let them know that you're running an illegal daycare. I'm going to do this if you don't do what I want you to do. Or, I need your help. I think it's important. We'll go shoplift. I mean, it sounds simple, but people do force others to participate in criminal behavior or any type of criminal behavior, whether it's driving under the influence or participating in other actions that the party may not want to, but feels coerced and pressured by the other person to do so.
So here's where we want to discuss kind of like, just like Dan said, that impact on the individual, right? And so, certainly this comes as a form of emotional kind of impact on the person. Certainly it can lead to that isolation and depression with that type of behavior, that isolation, the name calling, all of this kind of coupled together. Folks can certainly withdraw from their support systems, even though you may want to reach out to them, you just kind of tend to kind of pull back. Certainly that consistent and constant criticism of the individual can certainly kind of hamper a person's self-esteem, and also just those feelings of guilt and shame of where, that the name calling, the including that to kind of can make a person just feel helpless and just feel guilty and feel shameful for the behavior, when again it's kind of it's being kind of pressed upon them, if that makes sense.
And I look at this one as, and we all, it's the repeated conduct, right? That just keeps beating you down. If somebody does something once or twice, perhaps it doesn't impact the person that much, but it's over and over and over. And it's like the old phrase, the more you repeat it, the more someone wants to believe it, it becomes their truth. It's a lot of these things that's like with gaslighting. No, I said that to you a million times. And it makes the person, as long as they're receiving this and they continue to say, oh, maybe I did. Yeah, there's something wrong with me. Right. And then that creates fear, anxiety, you question yourself, and it allows them to emotionally manipulate you, right? Because it keeps going. And the example here is like love bombing. You'll see somebody, oh, I'll never do it again. I love you so much. And it's just, the perfect world for a couple of weeks, but then slowly goes right back into the same behavior that was being experienced. So you're into this cycle. And again, it's not the one or two times, it just keeps going and going, and it really beats a person down. And it's important to keep your eye on that and be honest about how it's impacting you.
And similarly, the impact on folks, the being able to have that confidence to be able to, take control over your daily life and make those decisions for your life. Okay, being able to not, like the example says here, fear repercussions from the abuser. Well, just like Dan said, with gaslighting, it's like, well, is that what happened? You start self-doubting and questioning your own judgment and your own decision making. And so it also here, as discussed, the restricted freedom, you're not just the mere fact that you have limited access to resources and communication devices to be able to reach out to your network and your support system can absolutely just break a person down.
This a lot of people may be aware of also. As you go through this, a person goes this, you get a different type of bond. Then with your abuser, you start feeling, well, the self-doubt is so great that without that person, what am I, right? I can't get out of this relationship because I have doubts of what I'm even able to accomplish. And trying to get then through that to break those bonds, to recover, to get your self-confidence back is very complex and difficult to do, because a lot of times you don't realize it's happening and you just it becomes a part of you. And just imagine with children that don't have all the tools that adults have, and not emotionally balanced as adults, it's much worse, right? And it defines who they are moving forward before they're even in a relationship. And it has to really be looked at because it could affect them for the rest of their lives.
Absolutely. And Dan, to piggyback on the impact on children, something else to think about is when the court will allocate decision-making responsibilities, the court has to consider, if there is domestic violence, so if there is coercive control that equates to a domestic violence, whether or not there are appropriate bargaining kind of abilities and power amongst the two parents to be able to make decisions together. So sometimes in this kind of scenarios, we're discussing that there's this control and there's this power, there's this kind of intimidation kind of factor over an individual. And so one impact that it might have on children is the ability to be able to make decisions together as two parents, because of that unequal bargaining power in the assessment.
Yeah, the court finds, my understanding is if there's that type of power dynamic and it prohibits the effective communication between the parents, they're going to allow one parent to make those decisions.
So what about false allegations? This is one of the questions that we often are faced with. This person is saying this, and but I'm not saying it. And on the flip side, this person is doing this, but it's hard for me to kind of put on paper, right? Like, so it's important that, I will tell you that it is very difficult to defend against, as you can imagine. Because ultimately what will happen is this person says this person says that, right? And so the court will have to determine the credibility of the parties when they're making these kind of findings and who they basically believe more. But as the slide indicates, most often the courts are going to understandably err on the side of caution for the children and parties. As you can imagine, these abusers, they sometimes will make sure that there's no other kind of third parties that will witness the behavior. So it can be, very kind of tightly confined in one's home, etc. But certainly I think it's always important to document. So anytime that you have this kind of behavior kind of done to you, that you indicate like, journaling behaviors, right? Like, well, on this day, this happened, and this is what was said. And on this day, this happened, and that was what was said or done, or et cetera. Certainly we have the ability, and there are tools that the court can appoint, kind of domestic violence evaluations. We have that ability. Dan, I'll ask you too. I haven't personally had the court appoint many of those. They're kind of a rarely used tool in my experience. How about you?
Yeah, pretty rare. I think the court, it's really that second comment. What I see with the courts, they don't want to be in a position of being told you so. And so they're more than likely than not, if it's even borderline, going to err on the side of safety and say, okay, I may not make a finding that's happening, but I'm concerned about this, and we're going to take these steps so the court can get perhaps more information on the background, have somebody independent look into it, have a therapist get involved to talk to the children and talk to everybody involved, and try to use other tools that aren't necessarily available in just direct examination, cross-examination, in trying to weigh the credibility of the witnesses and for the court just to get more information. And I think that in a few cases we've seen that's kind of happening here, but you do see that in a lot of cases regarding protection orders also.
Absolutely. Another tool that one could use is what's called a parenting coordinator. When you have a child together, that you can the court can appoint on their own, and that individual can help help with communication back and forth between the parties. There's also another kind of tool and a neutral third party that the parties can agree to appoint. The court doesn't have the power to appoint them, but the parties can agree to appoint, and that court can adopt that agreement is what's called a parenting coordinator / decision maker. So that person can help, kind of help implement the parenting plan of the parties and can help that with that communication pieces. And then sometimes make those decisions for the kiddo if they are given that authority within the court orders.
There's a lot of resources that we've tried to list here for anyone that has these concern, and they're listed here, and obviously they'll be available so if you get these slides, and all of them are really good resources that you take advantage of there and there for people to talk to and to address these issues with you.
Absolutely. And Dan, just to piggyback, I know that oftentimes folks won't leave a domestic violence situation because they're concerned for their kiddos and they're concerned for their pets that might be left behind, and what will that abuser do to the children or the pets, and they're afraid that they're going to get called for kidnapping or something of that sort. I will tell you, with the bottom number, Three Birds Alliance, it used to be called Gateway Domestic Violence Services, but they've renamed their organization. It's a nonprofit organization that will allow basically housing for victims of domestic violence and their children and their pets. It's one of the few nonprofits in the area that will allow pets to come and stay as well.
Good to know.
All right, we're at the question and answer time. Izzy.
Awesome. I'm going to go ahead and stop sharing. All
Good.
righty. So we got quite a few questions, so let's just jump right into it. The first one says, which I think is interesting, what if the other party says their behavior and their control is for the other person's safety?
Dan, you
Well, I
want
still
to?
think that would be, you're up to a person responding to that. And why would you need this behavior? The court's going to weigh that. You're going to hear almost every excuse for this type of behavior. And I think the court has the difficult obligation of weighing the credibility of both parties and looking at the behavior itself. And is it really necessary? Why would that person have to deal with that person's safety? I mean, there's a lot of ways you could go on this for about 25 minutes of weighing this, but really the court's going to listen to both parties, any other witnesses, or look at any other evidence and try to weigh whether that's a realistic statement.
That's right. And, it kind of goes back to that, is there gaslighting involved? Like, does that person need the safety, right? Just as Dan said. And so, I think that is certainly a statement that, one might want to very much look at the statute and look to these pieces and, discuss with professionals on if that statement alone to discuss whether or not that's coercive control.
All right, great. Thank you. I understand that coercive control and other abuse is only considered in extreme cases. Some of the examples you gave, such as name calling or threatening to kill an animal, um, would those be considered admissible as evidence or not significant enough to have weight in a case?
For my opinion, if it's concerning to the client, to the party, it's enough to raise the issue and the concern to the court, right? And what that example just given, that's right in the statute. That should certainly be discussed, and the court should be made aware of those statements and those threats.
That's exactly right. I'm looking here, and under section 1410 124 1.3 A4 is literally, it says name calling, degrading, or demeaning the individual or the individual's child or relative on a frequent basis. And with regard to the threat of the pet, number 7, threatening to harm or kill an animal with which the individual or the individual's child or relative has an emotional bond.
All right, thank you. What if the court denies the request for a GAL?
Well, GAL, my old practice, another state, we use those all the time. That's called a guardian ad litem. In Colorado, we don't use guardian ad litem, so I don't know if that's actually what you're referring to. A lot of times you have a child and family investigator, perhaps a parental responsibilities evaluator, and some other experts. My experience, it's pretty rare. If there's a concern that you can outline in your motion on why the court needs this assistance, the court's going to welcome it and say, yeah, okay, if you've shown me these issues, anybody that can help me make a decision, I'm going to defer and bring them in. So as far as the denial, honestly, I don't think I've had a denial when I've requested this type of expert. What about you, Jenny?
No. And to Dan's point, that's the guardian ad litem is basically, a person appointed by the court to stand in the shoes of the party. And so, if there's a motion that has been filed that says that a person needs a guardian ad litem appointed, just like to Dan's point, I've usually had the court say, okay, because they want to make sure that the person is their person's wishes and requests are adequately presented to the court. And so if a person doesn't have that kind of ability to understand what's happening in the litigation, they want to have a person to be able to be appointed to help that person through the process.
Okay, great. Thank you. We're having a lot of questions along the similar line of how do I prove it? How do I substantiate statements? How is this not all hearsay? Essentially, how do I prove it?
Great question. Document, document, document. Keep copies of text messages if things are in text messages, emails, and certainly email that to, if you have an attorney or to another resource where that person that is the abuser is operating that coercive control so they don't have access. You would not believe the number of times that I've had clients have emails go missing or deleted or something of the sort because they're monitoring their technological behavior and monitoring emails, etc. So you're going to want to email those that proof to another individual so they have the access to the information too. We all think that our phones are indestructible. I mean, Dan can attest that I mean, phones fall in water, rivers, puddles, like all the things. And so I personally, have had that to happen to me. And so you want to make sure you have your information backed up. And so making sure that your text messages are backed up. There's even like, applications and websites where you can change, all the text messages to one PDF. And so it makes it very easy for an individual in the court to read, to be able to turn into evidence. And so there's all sorts of opportunities, but make sure that you document and you back up.
Okay, great. Thank you. Can I call 911 to report this kind of domestic violence?
Certainly, if you feel in any way threatened or in harm's way, that's what 911 was there. Don't hesitate. That's not a mistake, right? They're not going to yell at you for making a mistake. If you feel threatened or in harm's way or in any way troubled, I wouldn't hesitate.
That's right. And just recall also, though, that sometimes, Dan, I'm sure you've experienced as well, where a person will call the authorities and that the person even calling the authorities has then been arrested. So just making sure that you're kind of understanding where you are in the situation as well, but also 911 always is a resource that we can all follow.
All right. This is the last one so far, unless anybody has any more that they'd like to submit. My situation is primarily financial control. I have no I have no access to finances without him allowing it. Is that enough to be considered coercive control, or does it also have to impact my safety and or well-being?
No, I believe that again, it addresses that. That's financial control, and that's coercive. I don't have a question. I think how bold statement. I think that's right in line.
I mean, I would argue that same statement, Dan. I think that Certainly there's things that one can do with the court on, how to access that information. If you're going through a custody kind of situation, a matter with the court or a divorce, then there's certain kind of things that the court can do. Certainly, one can ask for a temporary orders hearing to have temporary access to those finances, or temporary support. So you have money and be able to kind of get through, that legal process. So there's certainly things that you can do, but Dan, I'm so with you that I would absolutely argue that that's coercive control.
All right, and then we had one more come in. Um, how do I report this abuse to the courts? Just the logistics of how you get that in front of the court.
I would look at it as where you are, and how it's impacting the case as you're moving along. Like Jenny referred to, you can ask for motions to modify parenting time. You can look for protective orders. You can look to restrict some parenting time. You could go in and say it's coercive behavior or violating injunctions relative to property and finances. So it's kind of where you are in the case and how severe it is. I just consult with your counsel and say, these are my concerns. And good counsel, I think, you're trying to resolve problems, and would immediately reach out to opposing counsel and try to get this resolved, because nobody wants to get this type of information before the court if it's pretty obvious. So I think that would be the first step, just try to get it done as fast as possible with opposing counsel. Otherwise, bring it to this court's attention through a motion, request for a status conference. There's a lot of tools available.
That's right. And there's even third-party experts. So if you have, say, what's called a child and family investigator appointed to your case, you can have that discussion of that coercive control with that child and family investigator. You can also ask, there's individuals called the parental responsibilities evaluators that can be appointed by the court, which basically do a very full-blown, extensive kind of custody evaluation and can do medical evaluations, substance abuse evaluations, et cetera. And, so folks can kind of raise these issues with those individuals as well and would want to. You can, even if you're going through a divorce and say there's a financial expert kind of appointed to evaluate the value of a business or something similar, an asset, you may want to bring that information. If the person is asking you for information as well, you want to maybe mention the discussion, that information, because it's important for the expert to know how much information you may or may not have.
All right, and with that, we are right up against time. Do you have any final words, Jenny or Dan, for this evening?
Thank you for joining us.
Absolutely, I agree, Dan. And Izzy, we want to thank everyone for being, taking part with us this afternoon and evening, and we appreciate your time.
Absolutely, we do. Thank you all for attending. And as a thank you, and to get more of your very specific questions answered, as both Jenny and Dan will attest, every case is a little bit different. We'd like to offer you a free consultation to speak with one of our attorneys. Just give our offices a call and mention the webinar or give them the code Wiser Together. They'll be able to get you in for that free consultation to get more of those questions answered. And with that, we wish you peace and we hope to see you at another Wiser Together webinar. Have an excellent Wednesday, everybody.